Forgot to set it for Facebook. Hold on. See if I get this done. All right. We are rocking and rolling. We are going to start 10:30 sharp.
Good morning.
Anyway, this NAP not well thought through.
All right, everybody, it's 10:30. Good morning. Welcome to Thursday, August 15th. My name is Sam Saad, and today we are going to talk about the Florida Realtor Buyer Representation Agreements. I'm very excited. We've got a lot of people on the call. A couple of rules of the road as we get started. Number one, no talking about commission amounts, no bananas, no numbers. If you have a question and you want to use an example, use X percent or X dollar amount. Please don't make me mute you. Also, you can ask questions in the chat or unmute yourself and shout them out. I'm going to try and get through these slides. We got a lot to cover. We're going to talk about the Florida Realtor forms today. I did NAR forms a couple of days ago, and basically we're just gonna get started. So again, my name is Sam Saad, and I am an attorney here in Southwest Florida. And because I'm an attorney, we're going to start off with a disclaimer that I'm giving you information that is not legal advice. And if you have specific legal questions, you can call me separately, but we're not going to have an attorney-client relationship on this call today. With that being said, again, I've been an attorney now 20 years. I'm on the NAR's Legal Resources Committee that drafts the NAR forms. I'm on the FRBAR committee that drafts the FRBAR forms. I've done about 20,000 real estate closings, and I own a title company, so we've seen both sides of it. Happy to do your title work for you. Just give me a call. We guarantee you'll be the lowest closing cost, and we can close throughout the state of Florida. Today, we're going to talk about the NAR settlement. We're going to review the practice changes under the settlement. We're going to talk about the new and improved buyer broker agreement and showing agreement. And we're going to review the new compensation agreement forms. And then we'll talk about some tips and tricks. again, it's best to put your questions in the chat, but if you want to unmute yourself, feel free to as we go through these. All right, so let's talk briefly about the NAR settlement. This is kind of old news to everybody at this point who's been paying attention, but we had a lawsuit that NAR lost, $5 billion total judgment back on August 31st of 2023. On March 15th, the settlement agreement was signed in that lawsuit. It's a global settlement, actually across multiple lawsuits. And as of August 17th, our world changes dramatically, although for those in the Southwest Florida MLS, it's already changed with the removal of the compensation fields as of August 1st. One thing I'll preface today by saying is that everything I'm saying today could change because the final hearing on the settlement is not until November 26th, where the court will approve. And as of yet, we have not heard from the Department of Justice on this case as to whether they're going to weigh in and want changes to the settlement agreement. So all of this is subject to additional information coming out. So who's covered by the settlement? If you are an NAR member as of the date of the class notice, which is August 17th, then you're covered by the settlement unless you're one of the big brokers that settled on their own. And the small brokers, everybody under 2 billion, don't need to take any action to be covered by the settlement. So what are the practice changes? The settlement agreement itself is over 100 pages with all the supplements. But the most important thing to you, the realtor, is paragraph 58. And if you could get your hands on the settlement agreement, which you can at facts.realtor, then on the internet, I would definitely take a look at paragraph 58. But it basically outlines all the practice changes that are effective as of August 17th. As I said, the Southwest Florida MLS removed the compensation field as of August 1st. And the concession question seems to have been answered by the boards. It will be board by board, but the Southwest Florida MLS is allowing limited language about concessions. They're not allowing any amounts or percentages. They're allowing you to say the concessions are offered, concessions are not offered, or concessions are negotiable. And then there are a few other sections related to definitions and the paperwork the boards have to do. So what's changing specifically in the MLS? Number one, they're eliminating, prohibiting any requirement that listing brokers or sellers make offers of compensation to buyers or buyers' brokers. That's in the MLS. So there will be no offers of compensation allowed in the MLS in any form or fashion. I've heard a lot of things, I've seen a lot of things on Facebook about people who are upset about this, and I understand your frustration, but that's the rule, the new rule under the MLS. They're eliminating, prohibiting requirements that offers of compensation be blanket, unconditional, or unilateral, which means that you can now make conditional offers of compensation. This is going to ultimately make our lives a little bit harder as we have to negotiate our compensation in detail and in writing up front. They're prohibiting offers of compensation in the MLS, including removing all fields, and they're cannot facilitate any non-MLS mechanism for sharing compensation off of the, except for on your own marketing material for your own listing. So I want to talk about this for a second. The MLS have told me that you are allowed to put offers of compensation on your marketing materials, but it must be more than 2 clicks away from the MLS. So if you put your URL in your MLS listing, you cannot have a click out of MLS to a compensation. It's got to be a click to a page that you click on to the compensation. So just the 2-click rule, they're calling it. And we have a question. Trish is asking if I can share my opinion. Wondering if the best way to have the seller pay the selling broker, but Trish, I'm going to try to avoid my opinion on the MLS changes and the NAR settlement and just stick to the facts. There are a lot of opinions out there, but you need to be careful because everyone is watching. Omar is asking, can we not say the word commission? You cannot use it, commission, On MLS, Omar, that's correct. You can put commission on your website, but you've got to be careful to have the 2 clicks. Okay, so written buyer broker agreements are required. The agreement must specify and conspicuously disclose the amount or rate of compensation that you'll be receiving and how it will be determined. So buyers have to know what they're going to pay up front. The compensation must be objectively ascertainable and cannot be open-ended. So you cannot put in your buyer broker agreements that you will get whatever the seller is offering. And you may not receive compensation from any source that exceeds the amount or rate agreed to in your buyer broker agreement. So be prepared to amend those as you go through the process. I think that's going to be a big part of your practice, is getting your buyer broker agreement signed and then amended as you determine the compensation offered from the seller. Other terms of the settlement: you cannot say your services are free unless they are in fact absolutely free. That's what got us in trouble in the first place. And then listing agents must conspicuously disclose to sellers and obtain sellers' approval for any payment to the buyer or buyer's agent. And the writing has to be in advance and specify the amount. So sellers have to sign off on buyer broker compensation. That's always been the case in the listing agreement, but now it's clear in the settlement. And you cannot filter or restrict MLS data by compensation offered, and which is going to be impossible since they took the compensation out. Ed is asking, are we continuing to put the commission rate in the listing agreement, Ed? Yes, you are, and we're going to get to that in detail. So let's talk about the Florida forms. There are 3 levels of the broker relationship in Florida. There's the pre-showing agreement, the showing agreement, and the buyer broker exclusive agreement. And God bless Joanna Watkins, the Florida Realtors General Counsel, who's been helping everybody get through this. She had a great explanation for the Florida Realtors forms as to how they work. Think of these as dating and the levels of getting to know one another. So the pre-showing agreement is, let's get to know each other. Let's talk. Let's have coffee. The showing agreement is, let's date. Let's look at some properties, address specific. And the buyer broker exclusive agreement is more along the lines of, we're married to each other. Let's go look at houses and get you a property. So now I'll talk about these. We're going to go through them in reverse order because I think that the most important and hopeful relationship that you're going to have with your buyers is the buyer broker exclusive, although I think it's also going to be the most difficult to get signed. The buyer broker agreement in Florida comes in 4 versions based on the brokerage relationship. So if you think about your relationship, you want to talk to your broker. Most of you, almost all of you, are going to be transaction brokers. So you'll use the form that says TB2 at the bottom. On all of the forms, however, the first 11 sections are the same, and that's what we're going to go through today. Start off, you've got your parties, which you've seen on pretty much all of your forms. You've got now the notice. You are dealing with a consumer on the FRBAR forms. They call them consumer, not buyer. So you'll put your consumer name up here. If it's going to be an LLC, please don't abbreviate. Get the full legal name of the LLC off of the Secretary of State's website or from your buyer if you can examine their documents. If it's going to be a trust, make sure you put the trustee of the trust in here so that we know who we're dealing with, and then put your full brokerage name here. Please don't abbreviate because we want to be clear if there's franchises, which broker, because remember the broker owns the buyer just like they own the seller. So put the full complete name of your brokerage here. And this is an exclusive right to work with the consumer in locating and negotiating the acquisition of property described below. So it's going to be very important to describe the property that the area that you're dealing with. And it provides a very broad definition of what this agreement covers, including purchase, option, exchange, lease, or other acquisition. So the term of this agreement is, you have to be careful here as well. The term starts on the commencement date and ends at 11:59 on the termination date. But notice there are no defaults, so you have to enter dates. There is an automatic extension if the buyer gets a property and they enter into a contract and they're going to go to closing. This extends till closing on the transaction contemplated or until it's otherwise terminated. So your buyer broker does not have to be extended or modified if it terminates while you're under contract. Okay, very important section, section 3 of the buyer broker exclusive agreement. So these are FRBAR forms. NAR was the other day. This is a very important section of the buyer broker agreement. This is how you describe what the buyer is looking for. So you want to put the type of property, be it single family, condo, or townhome, or HOA, or no HOA, or just the types of property that they're looking for, and then the location where you're going to shop with them. Now, I've heard different brokers and agents say they're going to put the state of Florida or broad terms like Southwest Florida. I would be not necessarily as specific as possible, but geographically correct. So if you were to say something like Southwest Florida, well, I'm not exactly sure where Southwest Florida is or which counties or cities that includes. So I might write out the counties if I'm going to be shopping throughout Southwest Florida on my agreement. And then the other thing, I would not put the state of Florida, because I could very easily see a judge saying that that was not reasonable. And on all contracts in Florida, we have to be reasonable. Can everyone see my screen? I'm seeing in comments you can't see my screen. Let me see. Okay, you can. Somebody can. So I'm not sure, Tiffany, why you can't see it. All right, let's talk about your obligations. So this is an important section as well, because this is what you are selling. What are you going to do for the consumer? You're going to use professional knowledge and skill. You're going to discuss their property requirements and assist the consumer in locating and viewing the properties. And you are going to assist the consumer in negotiating and closing any resulting transaction. So this is where you come in and you say, I have exceptional professional knowledge. I know the area. I know the neighborhood. I know the building. These are my skills. I'm a good negotiator, and I'm going to use those skills to get you the property you want at the best price. You're going to talk to them about their property requirements, and then you'll help them negotiate the transaction. And by the way, this is a great opportunity to say, once we get the contract signed, that's when the real work begins. I got to get you to closing and financing, inspections, and I'm going to help you with all that. So you're just increasing your value proposition. This contract allows you to work with multiple buyers on the same property. So remember that your brokerage owns the buyer. So if you're in one of the larger brokerages and maybe there's 2 buyers with different agents interested in the same property, that's allowed under this agreement. It's not a single agency agreement unless you use the single agency form. And then there's the fair housing requirements. Of course, you're going to abide by fair housing rules. Those have not changed. And you are getting a release of warranty for any referrals that you make. If you refer them me, for example, and I do their legal work and they don't like it, they can sue me, but they cannot sue you. So what is the consumer obligated to do under this agreement? This is also a big deal because they agree to conduct all negotiations and efforts to locate property only through the broker, and refer to broker all inquiries of any kind from real estate licensees, property owners, or any other source. So this is where they are locked in. The buyer, the consumer is locked in. They're going to use you. You're going to conduct the negotiations and get them the property. And they have to advise other realtors that they have a realtor. I think that's very important that they understand that so that they don't accidentally sign 2 of these and then they're obligated to pay 2 commissions. The consumer agrees to provide accurate information. Yeah, yes, Cheryl locks them in for FSBOs. They're locked in for anything that they want to buy. It even says property owner right here. But they agree to provide accurate information. They agree to be available at reasonable times to meet with you and view properties. They agree to indemnify you for their actions should they, for example, damage the property. And they follow fair housing rules as well. And they agree to consult professionals for legal and other advice. This is an opportunity for you to be the source of the source, by the way. Okay. Cheryl is asking, is the broker required to sign because it's an agreement between the broker? So that is a broker by broker decision. It's a great question. We'll talk about that in a few minutes, Cheryl, but keep in mind that this is the broker owns the deal. And then yes, Peter, you would use the exclusive buyer broker for vacant lots for residential 1 to 4 family vacant lots. Remember, the settlement does not apply to commercial or leases, but it does apply to residential. And Florida's chapter 475, residential includes vacant 1 to 4 family lots. All right, so the next section of your buyer broker agreement under the FRBAR contracts has a retainer, which I think is fantastic. And I hope that realtors use this as an opportunity to get paid for their services up front. It's a non-refundable retainer fee. Put your amount here for the broker services provided to the consumer, and it is earned and payable on execution of this agreement, which means that they sign the buyer broker agreement, they write a check to the broker, not to the individual agent. Remember, you still cannot receive money except for through your broker. So the retainer goes to the broker, and then you should have a split agreement with your broker. And this retainer is in addition to any other compensation earned by the broker. So you get your compensation and you get this retainer. In the old Florida Realtor form, there was a choice to credit the retainer at closing. That's been removed. And then finally on retainers, just remember that if a consumer calls you and asks to get a list of rentals in the area, for example, you're not allowed to charge for that, but you are allowed to charge for pretty much everything else. Lauren is asking, you could give a credit at closing if you wanted to, Lauren. Yes, you could, but it's no longer in the agreement to suggest it to them. So in addition to the retainer, you get compensation. Now, compensation is earned when during the term of this agreement or any renewal or extension, the consumer contracts to acquire property as specified in this agreement or defaults on a contract to acquire. Yes, Trish, just put that in the other terms. The compensation is for broker services. The compensation received by broker in any form from an owner or owner's broker for services rendered to the consumer will reduce any amount owed by the consumer. So whatever you're entitled to under this agreement, the co-broke or the seller paid compensation to the buyer's agent would reduce the amount that you're owed under this agreement. And the way this agreement works, you've got your purchases, your leases, or your options, and you would go in here and you would put either a dollar amount or a percentage. Now, if your brokerage firm charges a transaction fee, then you would want to use this blank here for a dollar amount and this blank here for a percentage, because then in this blank right here, you would add your transaction fee. And you'll notice it says plus right here. So for most of you, it's going to be blanks number 3 and 4 and 5 that you will fill in for purchases. Then you've got your lease amount here, and you put in the number of months that the rent, the percentage of rent that you're going to collect is here, or you just put in your fixed dollar amount of the gross lease value, which I think is what most people use, gross lease value. Mary, you're asking about the retainer again. Yes, you can receive that amount as a credit at close. That's absolutely allowed. Broker will be compensated for all other types of acquisitions. And then you can put additional comments about fees that you'd like to collect here and additional fees. So a few thoughts about the compensation. It's due at the time of contracting if the consumer defaults on their purchase. And the seller co-broke, they said, reduces the amount of compensation. You must negotiate how you are paid now. That's, of course, what this agreement is for and what the settlement is about. You're paid at closing, but your fee is earned when the contract is signed. And you may enter, again, the other unique terms. Let's talk about the protection period. So the protection period, if you're familiar from the listing agreements, is when the term of your buyer broker agreement ends, you may have a buyer who wants to go back and buy a property that you showed them. So what this says is if you called to consumers' attention a property and they have an amount 30 days here, amount of time after you're done working with them, then they can't just go backdoor you unless they're working with another broker. And here it is, enter into a good faith exclusive buyer broker agreement with another broker. You get paid if they go back and buy a property during the protection period, just to make sure that you get paid for your work. Vivian, you're asking me to go back to 7A and talk about, there are two sections again, Vivian, on here because some brokerages don't use a transaction fee. Okay. Next up is the conditional termination. The conditional termination is a very useful tool for buyers who you're just not getting along with. They want to get out. It says here, at consumer's request, broker may agree to conditionally terminate this agreement. If broker agrees to conditionally terminate, the consumer must enter into a written agreement, which we're going to talk about, to the effect of the cancellation and pay a cancellation fee that you enter the amount here. It also says that the broker can void the conditional termination if the consumer will pay the fee stated in the compensation paragraph, less the fee, if the buyer contracts to acquire property that was shown to them during the term or the protection period. So what does this mean? It means that they can't terminate on you and then go back and try and buy a property that you showed them. You would still get paid if it's during the term. Daniela is asking if it can be canceled unilaterally. No, it cannot be canceled unilaterally, Daniela. You would need to sign off on it. Although I can see, we're given the nature of this contract, the realtor could say, I don't want to work with you anymore, and then the contract would be almost just terminated under its own weight, we would say. Okay, so under this agreement, there's also a dispute resolution clause. You go to mediation, and then if you initial here and here, you can have arbitration instead of going to court, and you do get attorney's fees if you win either at arbitration or in court. So that's kind of a cudgel with which we can use to keep the buyer in line. Say, if we terminate, if you sue me, if I have to sue you, I would get attorney's fees. So let's work together. And Terry, we're going to get to the showing agreement in a few minutes. Okay. So this agreement is owned by the brokerage. Should the brokerage sell, for example, this agreement would go with the brokerage to the new brokerage. So then there's the brokerage relationship, that's section 12. And basically it is usually you're going to be a transaction broker. If you are a single agent, and you want to show one of your broker's own listings, of course, you need the consent to transition to transaction broker. And then section 14 is just the acknowledgments and modifications, which are very important because it says that brokerage commissions are not set by law and are fully negotiable. The broker may not receive compensation from any source that exceeds the amount or rate agreed to with the consumer. However, the consumer agrees the broker may receive separate compensation from the owner, so you can sell your own listings. They state that clearly in here, and I think that's important. So lastly, before I get to everybody's questions about this form, let's talk about the signature block. Very important now, more than ever, that you fill in the contact information for your consumers. I need to know where to send the demand letter in the event that we have a problem with your consumer buyer. And it's super important that this now be filled out. On the, it was asked earlier in the chat who signs. This allows for the authorized associate or the broker. You need to check with your broker. And for the brokers on this call, please give your realtors clear advice, preferably in writing, about whether they're going to be allowed to sign these buyer broker agreements. I've heard a lot of brokers say that the brokers are going to be responsible to sign them all. And if you're in a large broker, that's a lot of work on Saturday. But that's the way it is in our business. I work Saturdays. All right. Oops. One second. Okay. So before I get into the next agreement, let's talk about some of these questions. Okay, let me scroll through here for a second. Okay, can you ask for retainer and tell the buyer he or she will receive that amount as a credit upon closing? Mary, yes, you can. If you are a transaction broker in a deal, can you choose to not charge the buyer and only the seller? You can always do that. So, and Guy, you're asking if another buyer broker signs a buyer broker agreement and negotiates the protection period. Yes, it does. That's just like the listing agreement. So if your buyer broker agreement ends and the buyer goes to another broker, they would sign up with them and then you would be out. Anita is asking, do we need this agreement to show properties to a tenant? No, you do not. It's only for buyers. Tenant leases are not covered by the settlement. Christina, you're asking, is there something like this also on NAR? Yes, NAR has its own buyer broker agreement. Let's see here. Next question. I'm going to get to the showing agreement in a minute. When searching for forms on app files or the form system, which form names do we use to be sure we have all the most current forms needed? So you need to make sure that you've got the 2024 forms, Jason. That's a good question. I would look at the trademark date at the bottom of the agreement. The seller does not need to sign the seller does not sign the buyer broker. Only the consumer and the broker. And Mike, you're asking about the statute of frauds. Statute of frauds does not apply to buyer broker agreements. Statute of frauds applies to the sales contract or to leases for more than a year. JJ is asking, how do we answer a buyer question pertaining to Section 9? How can I get out of this contract if I decide not to work with you anymore? JJ, they would pay the termination fee. And then you would agree to let them out if you wanted to. And then Lauren is asking, can I show a property for my teammate who is out of town if they have a buyer broker agreement signed with the buyer? Lauren, this is a great question. Remember that the broker signs, this is the brokerage owns the buyer. So if you have a broker agreement signed with the broker, and when I say broker, I mean it could be signed by an authorized associate, but the brokerage can do it. So other agents should be able to show them without it being signed. I wouldn't want you to sign two of these anyways. Or buyers sign two of these anyways. Cindy's asking if leases are not covered, why is there a section for leases? That's a great question, Cindy. They're not required under the settlement agreement with NAR, but if you're going to take a tenant out and show them property, I would want one of these signed to make sure that you get paid. So remember, you've always been able to sign these agreements They've existed for a number of years, and in other states, they've been mandatory for a number of years. Having these are now in place to protect you. And Lewis, I don't think they're going to put the co-broking for anybody, including rentals or commercial. I think it's coming out for everybody for all time now. Jennifer, if you are not a member of NAR, then this does not apply to you. That's an excellent question. Okay. Mark, I see your comment that yes, this contract is not worth the paper it's written on. How are we practitioners being protected? I would disagree with an attorney who said that, Mark. I see Florida judges upholding contracts all the time that I would think are otherwise badly written, but they look for contracts. They want to keep the deal together. Okay, I know it's a little boo-boo in my presentation, so we're going to skip a couple of these. All right, let's talk about the showing agreement. So marriage is not for you. Marriage is not for your buyer, but they're willing to date. They want to talk to you. They want to work with you on certain properties, but they're not ready to get married yet. So the Florida Realtors has produced a showing agreement. The showing agreement is similar to the buyer broker exclusive agreement in that you've got your parties, you enter before, put your consumer, you put your commencement date and your termination date and your brokerage name here. And it says consumer, it says parties agree that if between this date and this date, consumer becomes interested in touring, negotiating the purchase, option, exchange, lease, or other acquisition of any properties listed below, and notice, pay attention to this listed below language, consumer will utilize the professional services of the broker. Should the consumer enter into a fully executed contract for sale and purchase or contract to lease on the property listed in paragraph 2, the term of this agreement automatically extends through closing. So notice a couple of things here. If the consumer wants to tour, they will go through the broker. But the property has to be listed in paragraph 2 for you to get paid. So what does paragraph 2 look like? It's a list of properties. So you would put the address of the properties that you're going to show here. And then if the consumer buys one of those properties, you would get paid if they're listed, but only if it's listed here. So it's very important. I've had the question, what happens if we go out and I'm showing them properties? I got 5 properties listed on here and we go to 5 properties. At the end of the 5th property, they look across the street at a 6th property and they say, gosh, I really like that property. Let's go take a look at that. How do you handle that situation on the showing agreement? The buyer broker exclusive agreement is easy. This one is a little harder. You've got to amend this agreement. What I would do is have this agreement with you and just write it on there. Write the address that you're about to show them right here, initial, date, and then go look at the property. Okay. So what are you going to do under this agreement? Very similar to the buyer broker agreement. You'll use professional knowledge and skill. You'll use diligent effort to show them the properties, and you are allowed to work with other consumers on the same property. Guy, I would not put, you cannot put residential properties in Collier County on the showing agreement. You're supposed to put addresses there. Is how that form is designed. So don't just put general, do not put just general locations. This is property specific. The consumer, again, they agree to negotiate through you. They agree to inform other licensees of this agreement. They agree to provide accurate information, consult professionals, and make a good faith effort to close, a diligent good faith effort to close and perform under the terms of any contract that they sign. So how do you get paid under this agreement? Again, with the compensation, broker compensation is earned at the time of contracting. It says here, contracts to acquire real property. Any compensation paid by the seller reduces the money owed from the consumer, and it's payable at closing, but closing is required to earn the fee. So you've got to get to closing. If they terminate, you don't get paid. And again, you put your amount here and here, and your transaction fee here. If you don't use a transaction fee, you can use these blanks, these first blanks. And the same thing goes for leases if you want to use this for leases, although again, it's not required. So this form, similar to the buyer broker, has got a non-refundable retainer allowed. It's in addition to any compensation earned. It has blanks for additional terms should you want to be more specific. And it allows for mediation and arbitration. And it does state that you cannot get more compensation than what is stated in this agreement, and you can still have the listing side. Okay. Questions about the showing agreement or the buyer broker exclusive? Let's see what we've got in the chat. If you're selling your own listing, you need a buyer broker agreement for a buyer coming in without an agent, Lewis is asking. Lewis, is an excellent question. You do, if you are going to be working with the buyer in a transaction brokerage relationship, you need a showing agreement or a buyer broker agreement signed with them, even if it's your own listing. Otherwise, you would want the no brokerage relationship form signed so that it's clear that you are not working with them. And Teresa's asking, what about non-rep? So you could have a non-rep, Teresa, if you wanted to. And then Sigrid, you're asking with the pre-tour agreement, don't worry, we're getting there. Tiffany is asking, as the buyer's agent, does the seller need to see this agreement? Tiffany, that's an excellent question. Does the seller need to see the buyer broker agreement? No, they do not. And you don't need to see the listing agreement. What you need are the compensation agreements that we're going to talk about towards the end of this presentation to go between the brokers to talk about the compensation that's going to be paid. And we'll get to that in much greater detail in a few minutes. Oops. So let's talk, oh, that's right. So let's talk about the modification of this agreement. So if you want to modify either the exclusive buyer broker or the showing agreement, you are provided this form to modify. And you'll note on here, you can change the termination date, you can change the compensation, you can change the protection period, the cancellation fee, or the parties can agree to conditionally terminate on a date certain, and you would get your fee, your termination fee paid, and you would terminate. It also provides an unconditional termination where you just check the box, everybody signs, and the buyer broker or the showing agreement goes away. What I will tell you though is on this form, you've got your consumer information and your broker information. And then on the date here at the top is the date of the original buyer broker agreement. So I don't know if you can see the little hand on the screen, but it is the date of the original buyer broker agreement. Okay, let me get the zoom off. All right. So let's talk about the property pre-touring agreement. So again, marriage didn't work out. They're not ready to date you yet, but you wanted to let them know what your compensation is going to be. So you have this form here. This is the property pre-touring agreement. You put in your real estate licensee with the brokerage, put the brokerage name, you put the consumer's names, and then you put the number of days for which they're going to mutually agree to pay you. And let's zoom in on the compensation. You tell them that you are brokerage commissions are not set by law and are fully negotiable. They do not owe any compensation at this time. Hold on, Fred, why are you marking on the screen? Careful, those green lines are somebody else there. Hold on, let me fix that. I don't know how to fix it, but that's Fred marking in the green. So Fred, stop doing that. I've not seen that before in Zoom. Anyway, so you put the fee that you're going to charge them or the percentage that you would charge them here, plus the transaction fee there. And then you can go out, and if you do show them properties, allegedly this form will suffice. I personally, having looked at this form and tried to figure out what the real purpose of it is, and I notice here at the bottom that even Florida Realtor says they make no representation as to the legal validity or adequacy of the provisions of this form in any specific transaction. So I'm not sure that this pre-touring agreement is very useful, although it does exist and Florida Realtor says that you can use it. Jim is asking, can you modify the compensation for just a specific property? Jim, absolutely. You can amend your buyer broker agreement or your showing agreement to be to a specific property. Yes. Okay. So before I get to compensation agreements, does everybody understand the 3 levels of relationship that Florida Realtors has set out? There's the buyer broker exclusive, the showing, or the pre-touring. And those are the agreements that you're going to want to get signed prior to touring a home. Remember, the settlement agreement is says prior to touring a home, you will have an agreement, written agreement in place with your buyer.
Hey, Sam, sorry to jump in, but a quick question in regard to code of ethics that says that we cannot discriminate based on compensation. So if you've got somebody who does not want to pay, then we have to put them under a non-rep. My understanding is if it's my own listing, I can open the door, let them in, see the property. And then if we start to engage in conversation to work together as far as fees, numbers, offers, then I have to put them under agreement prior to that. Can you elaborate?
Right.
Oh, that's
No, you said it very well. So if you've got a listing and someone knocks on the door, if it's an open house or not an open house, and someone knocks on the door and they want to see your property, and you say to them, I represent the seller, this is my listing, you can look at the property, but I'm not working with you. You give the no brokerage relationship notice, so they know that you have the 3 duties, but not a full relationship. And then you can move forward and let them view the property. If, however, they want you to write the offer, for example, and you're going to write the offer for them and not for the seller, because typically the buyer writes the offer, then you would need something in writing from them saying that you're working with them and what the compensation to you is going to be from them. It puts you in a situation where you know what the seller may be offering as a co-broke, and so you'll want to talk to your seller and confirm how that's going to work. But you can then put the compensation on a buyer broker or a showing agreement or a pre-touring agreement, and then you could write the offer for the buyer and we go to closing.
Do we have to disclose to the buyer? If a buyer says to you as a listing agent, is your seller offering a compensation? Do we have to
So
disclose?
that's an excellent question, whether it's asked by a buyer or another realtor. That comes up quite a bit in these talks. And the answer is it has to be negotiated. So sellers, if you look at the listing agreement, I'm going to show you the listing agreement when we get to the end of this. Sellers are authorizing in the listing agreement the offer of compensation. Whether you as a listing agent have to give it immediately to a buyer's agent, I hope that you will, although I've been told by many agents that they will not, because they want to see the offer first so they can give the seller a better idea of what their net is going to be. So I think that it really, the most important thing is that we all try to work together to get these deals done, although I see where it's going to be a fight to get that co-broke compensation information from the listing agent and from the seller initially, although it's going to have to be turned over eventually because you want to do a deal. So how you do that, I think, is going to be situation specific. And I hate to be vague about this, but I get a lot of questions and a lot of realtors get upset and frustrated. But you got to remember, the Department of Justice goal, the plaintiffs in the case, their goal was to make this a more transparent process and lower commissions. So it's going to be a frustration, I think, for all of us for a little while going forward.
I think that's almost why it's almost contradictory to share up front what your compensation is going to be, because then we've predetermined it for the seller before he's even seen an offer.
Right. And I think that that's right. You're gonna see sellers want to fight about it. Buyers are going to be frustrated. I see in the chat here how it's going to be confusing. And I think that's why I'm going to keep doing these webinars, and we've got to talk about this and come up with a better system. And I do think the settlement agreement, God bless the people that wrote this. They didn't think through all these individual issues with so many options out there and so many, more state specific rules that we've got to follow. So it's going to be a difficult road ahead to figure all this out. Yeah, Teresa, I see your comment about the green marks. I saw Fred put those on there and I don't know how to get them off. So we'll figure that out for the next one. Fred is asking, can the buyer broker ask for a certain amount of compensation, which is more than the 50% of the total commission the listing agreement states? Fred, remember, these are separate sides now. The buyer broker can ask for whatever they want. The buyer has to approve, to agree to pay the compensation. And if the seller is going to offer a co-broke, the seller's got to approve the co-broke. So there's going to be a lot of conversation about, who pays what and when. Let's see, Maria is asking, agent is obligated to disclose. Maria, that's an excellent point on question 49 of the settlement facts. Give me 1 second. I've got the settlement facts right here. Section 49. We talked about this on the call that I did the other day. Listing brokers should explain to their clients the benefits and costs of various types of marketing that can be done for listings and how potential buyers might respond to, offers to pay. A listing broker should inform the seller about the cost the buyer will incur. The buyer may react to those costs and how the seller can market a house considering the buyer's costs. But a listing broker must not tell a seller the broker will steer buyers based on the amount the broker is compensated. So that's the steering provision, yes. And again, there's nothing in the settlement agreement or the Realtor FAQs that says you have to share the amount of compensation up front. But I think if you don't do that, you're going to find that you're going to have problems. So hopefully we can not do that. Karen is asking, can you change the percent on the listing using the buyer's form? No, Karen, the listing agreement is between the seller and the listing agent. The buyer rep agreement is between the buyer and the buyer broker. Let's see. And Omar, this is a great question. Who makes sure these agreements are signed? I'll tell you right now, the MLS is going to make sure these agreements are signed. They have audit rights if you want to be a participant in MLS and a member of NAR, and they've all said they're going to ask for these agreements and fine you if you don't produce them. And realtors are going to be policing each other the way we always have. So I think that's going to, again, it's going to be a communal effort to get through this process until we come up with some better standards. Okay, let's talk about compensation agreements because those where a lot of these questions are going. So how do you make sure if you've got the buyer that the seller side is going to pay the co-broke, pay the compensation? To that end, some forms have been provided, 2 specific forms. This is the seller's broker to buyer's broker form, and we're going to go through it in detail. You put your seller's broker name at the top. You put your buyer's broker name here. You put the property address here. And it's optional to put the buyer's name here if you want this to be specific. Now, I've heard some pushback from some brokers about putting the buyer's name as optional. I'm not sure if you're going to want to put the buyer's name on here. You may not want to reveal that information to the listing agent immediately. Of course, they'll see it on the sales contract, but if you have this signed prior to that, then you might not want to put them on here. So the term of this agreement is in a period of days. So you put the number of days this is that this compensation agreement is going to be valid for. And notice that it does not go past the termination of the listing. So if the listing agreement ends, this compensation agreement ends. And it automatically extends through closing if there's an actual closing date, which most of your listing agreements will also extend through closing. So then you put your compensation. Seller's broker will compensate buyer's broker as stated below at closing of the property if the buyer identified above in paragraph 3 closes and buyer's broker is the procuring cause of the sale. If no buyer is identified in paragraph 3, then the buyer's broker gets compensated if they are procuring cause. What does all that mean? Well, what it means is that we're going to have a lot more conversation about what is procuring cause. So let me take a second to talk about that. To my understanding of procuring cause, as limited as it is that it's the last best act to get the deal signed. So if you've got a bunch of agents competing and talking and nobody's done this properly, which I fear is going to be the case, it's the last best act to get the deal done is procuring cause. In that case, the seller's broker agrees to compensate the buyer's broker as a flat fee, as a percent of the purchase price, plus maybe another fee, or other as determined. And then you can also have other terms of the transaction. So this form also allows for arbitration in the event that you have a problem, the broker's initial, and then you can have arbitration as opposed to going to court. This miscellaneous clauses section, to my mind, is super important because what this says right here is this agreement represents the entire agreement and understanding between the parties and the subject matter herein and supersedes all prior contemporaneous agreements. So when you guys are texting back and forth with the listing agent trying to figure out the compensation, and there's like 200 text messages and everyone's trying to determine what it is, once this compensation agreement is signed, all those text messages go away. The judge won't even see them in the dispute because of the parole evidence rule. So make sure you get these compensation agreements correct. Put the amount or rate of compensation on here. Be clear. If there are other terms or other information, make sure it's written clearly. And then the brokers sign. Okay, we've got some questions about this form. Let me go through these. Okay. The buyer calls you from the sign, wants to see your listing, and you meet to show the house. Do you need to have the buyer sign a form? Either not, we answered that. You would want to have them sign something. If your seller does not want to offer the buyer any compensation, how do you update your current listings? So all of the compensation, Karen, has come out of the MLS. So there are no offers of compensation. When you receive a call about your listing, you would simply say there is no COBRA. Maria is asking if the listing agent chooses to conceal how the compensation is paid, do they still have to at least say that it exists? Maria, that's an open question and it's not addressed by the FAQs. I would say they do not have to show how it is. They don't have to say anything about it other than make me an offer. And so, again, we have to work together. Let's see here. Do you need a signed buyer broker agreement to send the listing to a consumer prior to showing the properties? Beth, I'm not sure I understand, but do you need a signed buyer broker agreement to send? You don't need to send the buyer broker agreement anywhere. You just need to have it signed and in your file. And then Teresa is asking, would you recommend we get this signed prior to submitting an offer? So that's a matter of negotiation, Teresa. When you get these compensation agreements signed is going to be a big deal. I've already seen them come across with offers, and I'm not sure that's the best practice because if the offer, maybe they accept the offer but don't sign the compensation agreement, now your buyer is in contract, but you're not going to get paid because you don't have a co-broke in place through the MLS anymore. So I'm of the mind that these compensation agreements should be signed prior to the offer, but I know that's going to be a problem for a lot of people. In that vein, however, if you do get them signed and then there's a question later, there is this modification form that you can use to modify the broker compensation. And this is what it looks like in its entirety. Again, the seller's broker and buyer broker sign, you put the property address and you put the term to be extended here or the compensation here, and this modifies the compensation agreement. And then you can put other terms as well, and the brokers would all sign. So the other form is what happens if the seller is going to be paying the compensation instead of the seller's broker? Or what if you go to a FSBO? And the answer to that is Florida Realtors provides the seller to buyer's broker compensation agreement. This is where the buyer's broker signs, the seller name goes here, the property address, and then again, you've got a term for so many days, and then you put the compensation that's going to be paid, however, as a dollar fee amount or a percentage of the purchase price, and then the seller signs. Now, what happens if during the term of negotiations, you decide you're going to modify the compensation that the seller is going to pay? You have a modification agreement here. And again, it works the same as the other one. Oh,
I don't know.
Question? Okay, no. All right, so I'm showing you now, I've showed you the agreements that are for buyers and between the brokers. I want to show you a zoom in of the listing agreement under Florida Realtors to further explain the compensation agreements, because there's two forms of compensation agreements that we've just gone through. There's the seller's broker to buyer's broker and the seller to buyer's broker agreements. And I get a lot of questions. Why do we have two of these? So the answer is because in your listing contract, you have two choices. You can either have the seller authorizing the broker to offer compensation paid by the broker, or the seller can authorize the broker to offer compensation paid by the seller, or there can be no compensation offered. But if you check this box, for example, box B, you would want the seller to sign off on paying the compensation to the buyer's broker instead of the split with the seller's broker. Okay. Before I go to my last little form, I'm going to answer some more questions. Let me go through here. Sigrid is asking, I understand we can use the FRBAR forms and use the NAR sales contract. Yes, Sigrid, you can do that. That's perfectly allowed. Just don't mix the forms. If you've got a sales contract under NAR, use the NAR addenda and amendments. If you got a FRBAR contract, use the FRBAR comprehensive rider. Don't mix the forms in that regard. But if you've got a Florida Realtors buyer broker agreement, you can still write it off on a NAR form. They don't relate. Daniela, you were asking an excellent question. Can we make the offer contingent on the acceptance of the compensation agreement? Danielle, you absolutely can. In your sales contract, I foresee this happening quite a bit. It already happens in commercial deals all the time, so it's not a big deal. You will write something like, seller shall pay buyer broker compensation in the amount of X to buyer's broker, or some form of that language can go right in your sales contract. As a matter of fact, there are NAR offers an amendment to do just that. Okay, Amy, you're asking if the seller broker does not pre-sign, then can you write in the offer itself? Yes, you can. Mike is asking, can the sales contract be subject to execution of the compensation agreement? Same question, absolutely. Christina, same question. And then Debbie, is that only Debbie? Yes, the one form I showed you, this one is for FSBOs, but it's also when the seller's going to pay under the Florida Realtor listing contract, and you check that box I had pointed out here, this box here. Beth is asking, to clarify, you are considered working or required to have a signed buyer broker agreement when you begin looking for homes for a customer. Beth, it's prior to touring a home. So you can bring the consumer into your office, you can show them listings, you could talk to them on the phone, but before you tour a home, you must have a buyer broker agreement of some kind signed with them. So that includes FaceTime showings as well. Mary is asking, the limitation of the time on the buyer broker exclusive, Mary, is whatever you write into the agreement. It's not like California. Teresa is asking, how are you going to handle compensation, or want to determine where's the change there? That's another excellent question, Teresa. So in my office, we are not going to ask for the buyer broker agreement and the listing agreement. We are going to prepare very clear and specific commission verification forms. And those commission verification forms are going to be signed by the realtors and or the brokers, and we will pay based on those forms. So you will all see, and the buyer and seller have to sign off on the compensation, of course, so they'll sign the settlement statement. Your compensation will be on the settlement statement, and everyone will be happy. Okay, JJ is asking, can't a buyer's agent just put language in the additional terms of the offer contract that seller agrees to buyer's broker X%? No, absolutely not. JJ, that's specifically not allowed. You must have a clearly ascertainable compensation in the buyer broker agreement. Maria is asking, how do we choose what compensation agreement to send? Well, Maria, you have to ask. You've got to ask the seller's agent, the listing agent, are you paying the compensation through your co-broke, or is the seller paying it directly? And then that would tell you which form to use. Trisha is asking, oh, she's answering another question, I see. Okay. Lisa, I do not have the new modification to listing agreement in this presentation. I'm going to prepare a separate listing side presentation here in a couple of weeks. Linda is asking, how's the compensation going to show on the settlement statement if broker authorizes compensation to buyer's broker? Linda, that's another great question. So the buyers, we will put the compensation on the settlement agreement, on the settlement statement, as determined from the commission verification forms that we receive. I have one thing about the listing agreements I want to mention before I answer a bunch more questions, and that is this. If you've got a currently existing compensation disclosure, a currently existing listing agreement or buyer broker agreement that does not comply with the settlement terms, you simply need this disclosure to send to your buyer or seller, telling them that noted brokerage compensation is not set by law and fully negotiable. And that will bring your Florida Realtor listing agreement into compliance with the settlement. This is different from the NAR disclosure, so be careful about that. All right.
Could you also use the listing modification form that has the language in it, the new listing modification that has the language in it that talks about all buyer broker or all broker compensation is not set by law and fully negotiable?
Yes, you can. Yes, you can. Yes, you can, Trish.
And then going back to JJ's question, you said, no, you couldn't put it in the contract, but then previously you said you did. Could you provide clarification there?
Oh, I see. JJ, I'm sorry. You said in the initial terms of the offer. I thought you meant in the buyer broker agreement. Yes. So JJ, yes, you can. I apologize. Good catch, Trish. Yes, you can put the offer of compensation in the sales contract and make it contingent. You just cannot put an offer of compensation that is contingent in the buyer broker agreement. It's got to be definite and certain. So hopefully that's clear. Okay. Annette, you're asking a very hard question. If the buyer tells you, I do not want to pay your compensation, only show me properties where the seller pays your compensation, do you put a 0 and sign the buyer agreement anyway? And you can't put 0 in there because then you get paid 0 even if the seller is offering it. And the settlement agreement is pretty clear that you're not supposed to sort based on compensation. What I would say is that I'm not sure how it's going to be handled, but if the buyer can't afford to pay you, but the seller is offering a co-broke, then you would have to talk to the seller's, the listing agent about the co-broke information and get that information from them and either put it in your offer and put it in a simple showing agreement. And so the buyer understands, because remember, the money comes from the buyer. So the buyer is paying no matter what. Dean is saying, can you modify the buyer broker agreement when it's time to write the offer? Yes, you can. Okay.
Sam,
So those of you that were on, yes, Lauren?
all right, I want to go back to the writing it in the purchase agreement, the offer of compensation.
Sure.
So over the past 3 years, I've been told by another attorney that we are not allowed to put compensation in the purchase agreement due to the verbiage on lines 643 and 644 that say this contract shall not modify any MLS or other offer of compensation made by seller or listing broker to cooperating broker.
Right.
Does that not apply?
You're not modifying the compensation that's offered by the listing agent. As a matter of fact, if you put an offer of compensation in your offer, or I mean, if you put it, what I would put in a sales contract is seller shall pay buyer's broker. And notice the language I'm using. Seller shall pay, not seller's broker shall pay, because the seller is obligated to pay the listing broker based the commission that's stated in the listing agreement. And if there's a co-broke, the listing broker can pay the buyer's broker. But when you're making your offer, as you noted, you can't modify, the seller can't modify the listing agreement in the contract with the buyer, because the listing agent or the listing broker has got to agree to it. So when I say that you make an offer of compensation, I'm saying you put seller shall pay. Now, if the seller has authorized the listing agent to offer the co-broke, then I would make my offer, and I would, if I had to beg or ask the listing agent for the amount to put in there, put it in the offer, and I would still put it in the offer and say seller shall pay, and then the listing agent's got to work it out with the seller to make sure that the seller only pays the top line number that they agreed to as compensation, total compensation. Does that make sense?
Thank you for the clarification.
Yep. Okay. So Maria, I'm not going to be able to give legal advice on this call, but if you want to email me separately, we can talk about what to put in your specific offers. All right, so I've been doing this for a long time, and for those of you that saw the NAR presentation, I've changed the slides a little bit, but not too much. But again, I've done 20,000 transactions almost, and I've seen a lot of crazy stuff. So I came up with a few thoughts. First of all, as a realtor, you've got to stay educated. You've got to have local market knowledge, and you've got to be prepared to give advice all the time on all types of things related to real estate. You've got to be accessible. Your market's moving fast, so you've got to stay accessible. And I love this quote from Inman. I hope that you all make more money, not less money, as a result of this change if you're working with buyers, because now your buyers are going to be paying and you're going to be locked in. And you've got to learn to do research. You've got to understand the communities that you're selling in. You've got to know people in the building department. You've got to have good insurance people. You've got to understand the documents that you're dealing with, and you've got to be able to read the title. And I, of course, am always happy to help you with that. And you should always be the source of the source. I love that phrase. Be the source of the source. Know people who know things. You've got to build relationships that last. You've got to be known as the agent that gets the deal done, because it brings clout with other listing agents. If you're the one that brings the deal, I think it's going to be more likely that a listing agent is going to tell you the compensation, because you're not wasting their time. And I think that's going to be really, really important, that you are an indispensable resource. And my last thought before we open it up to any questions you have is know your value. I just love this quote. I've worked with thousands and thousands of realtors who bust their butts every day for their customers, and it's fantastic to watch. It's kind of inspiring to me. But here's what I think. Buyer's representation is quite comprehensive. It involves ongoing communication, being extremely proactive, problem solving, troubleshooting, double and triple checking, following up and assuming nothing is as been purported to be. Buyers don't know what they don't know, and those who don't have representation often find themselves in a problem or situation that can have serious financial implications. And this is what you do for them. You save them money. They're going to pay you a pittance of what they're going to lose if they end up in a lawsuit or if they overpay for a property. So be mindful of your value. You guys are awesome. And with that, I will take questions. Let's see, Joe, if I have a listing and the seller agrees to compensate a certain amount to another buyer's broker, I am not understanding why a listing associate withhold this amount, which may be a huge benefit to the buyer and increase the sellability and desire for the property. What am I missing? What do some feel they don't disclose the offer of compensation before they see the offer when it's already been discussed and agreed to by the seller? Joe, that's an excellent question, and I hope the rest of the world sees the way you see it. If the seller says they're going to pay buyer X, it's not necessarily a secret. Say what X is, you know? And I know that, for example, some realtors are already advertising the co-brokes and the compensation on their websites and in their flyers and in their e-blasts, and that's perfectly fine under the settlement. And I hope that things like that continue. So, okay, and you can unmute yourself and ask a question if you've got them. Anybody? Come on, there's only 187 of you. You must have a question.
Hey, Sam, Joan Crumpton, will you be
Joan.
sending out the video of this?
I'm going to post the video to my YouTube channel and send a link here in a few hours.
Thank you.
Yep.
Sam,
Yes, go ahead, Trish.
can you identify exactly, let's do a certain scenario. You've got a buyer who comes to you as a listing agent that doesn't have any money to pay you. How do you have them sign that non-rep agreement that there is no money, since we can't put zero in the buyer broker agreement?
That's the whole rub of it. That's why this settlement is so weird. The first time home buyer, the young couple, the veteran who's getting a VA loan, people who are putting 100% down, they're the ones that are hurt most by this settlement. And that's because they're going to have to sign an agreement to pay you some money in order for you to write an agreement for them. And if you write zero, you get zero, because under the settlement agreement, you only get what's in the buyer broker agreement. So you have to very clearly explain to your buyer, hey, buyer, see this line right here in this buyer broker agreement that says the listing, whatever the seller pays offsets what you owe me. And then you have to say the seller has agreed to pay X. So I'm going to put X on this agreement and the seller will pay it and your net will be zero. And that's hard to explain to the unsophisticated buyer, but that's the way you're going to have to handle it. Does that make sense?
It does make sense. It's just a little muddy for
It's
the
very muddy.
consumer.
It's very frustrating for someone who's trying to explain to a new buyer or a new unsophisticated buyer, I'm going to put down X% that you owe me, but the seller's going to pay it out of closing, and see this line right here in the contract. And I can flip back to that slide. It doesn't make people too dizzy. I mean, this is the showing agreement, but it says
What about the disclosure
right
that's
here, will
not-
reduce any amount owed by consumer per this paragraph. So you would just show them this sentence and say, if the seller is paying X, I'm going to put X on our agreement and the seller will pay it.
What about the buyer broker non-rep form?
You could use that, but then you don't represent the buyer in a transaction brokerage relationship and you owe all your duties to the seller and you have to explain that to the buyer. So then you're like, well, the buyer says, well, wait, I don't have any representation. So be careful there as well.
Sam, couldn't we just show them the signed buyer compensation, call ahead of time, find out what it is, have them sign it as a listing agent, then show it?
That would be excellent. If you get a seller or listing agent to pre-sign that, that would be an excellent way to do it. Yes, Christina.
Some
Right.
people are saying that they'll do it at no charge if it's their listing. I mean, my understanding is errors and omissions does not cover you if you offer free services. Is that correct?
That I do not know. Errors and omissions insurance is definitely something I am not an expert in. Okay, let me go through some of these questions. Can a seller take all offers before deciding whether they pay a buyer's broker or not? Because it seems they should be more concerned about what their net will be, whether they pay the buyer's broker. Carmen, you could have a calling all offers type of situation. That's certainly allowed. And to say, we want to know what compensation you're asking for as part of this, so we can give seller net sheets. I think that's perfectly fair. Now Natalia is asking, so we just need a showing agreement and then buyer broker agreement to start with. Natalia, you need one or the other. They're levels of the relationship. The showing agreement is property specific. The buyer broker agreement is for any thing that the buyer might buy, whether with you or not with you. Rosemary is asking, can you ask the buyer and add to the buyer broker agreement if they only want to see properties that offer to pay the broker compensation? I would not do that, Rosemary, because the settlement agreement says you won't filter by compensation. So let me just pull that up in the settlement agreement. I'll read it to you. It's in here somewhere.
Seems like the code of ethics and this conflict in many different areas.
They do. The code of ethics, there's a section, we talked about this yesterday on a private call I was having. The code of ethics, I can't remember the section, says that you're supposed to be cooperative with each other. And the FAQs that I read earlier, 49, says that as well. And I hope that people are. I really want agents to work together to get these deals done. It's better for the market. It's a healthier market if there's a free flow of information. I just fear, and we all know the agents that we know that I'm talking about, where they're going to be cagey and they're going to, they think they're doing a service to their seller, getting them a better deal by negotiating compensation, even though they're supposed to have had that conversation with the seller up front. And it's supposed to be in writing on the listing agreement. I just have this great fear that it's not going to work that way, and we're going to be fighting about it. But I hope that I'm wrong.
Sam, I know you're talking about FRBAR, but I could have sworn on the NAR BBA, there is a box, what Carmen was just talking about. There's a box that you check.
It's for concessions, not compensation. Yes, on the NAR buyer broker, you can filter by concessions, but not compensation.
And the concessions cannot be earmarked for commissions, but they could be used for commissions.
They absolutely could be used for compensation, and it says that in the NAR agreement.
Okay, and when they say that it is in there, I mean, or even in the FRBAR, does it mean that $1 of it must be concessions and then the rest can be towards commissions? Or does it mean it's up to this buyer that receives those funds?
Christina, money is fungible. So most buyers want to know two things. How much do I need to bring to closing? And what's my monthly payment? So for the buyer, if they receive concessions, but they agree to pay compensation, they want to know the net out of those two numbers. That's what matters to them. So buyers have closing costs, buyers have cash to close, and buyers have compensation that they have to pay, and then they receive concessions. So they're looking for that net number.
Thank you.
Yep. Kathleen is asking, should a compensation agreement be sent with an original offer? You could do that, Kathleen, although I think you're going to want it set ahead of time if possible.
Sam, I used already the agreement seller broker to buyer broker, and then my real estate company told me I should use the broker to the seller, not the opposite way. Does it really exist, or is that just the fantasy form they have in my broker?
No, I showed you both of those forms. There's the listing broker to buyer's broker, and the seller to buyer's broker. And it just depends on who's paying the compensation based on what box was checked in the listing agreement, or whether it's a FSBO.
No, I was the buyer anyhow. So I was the buyer, and we agree with the seller that we go to a certain amount and back and forward. That was all good. But then we signed this paper, what was for me right, because the seller pays me at the end as a buyer agent. And then my brokerage told me, we have also a form that says that the broker the buyer broker to the seller has an agreement form. I do not know if that is just something they find out or they did themselves, but I have never found that officially on FRBAR or somewhere.
Well, like I said, I showed you the two forms that FRBAR offers. There's
Mhm.
the compensation agreements between the listing broker and the buyer's broker, and the compensation agreement between the seller and the buyer's broker. So
Yeah, and they want to have that reverse vice so that it is a buyer's broker to seller's broker. What is kind of strange to me.
that does sound a little strange. Contact me offline. Let's talk about it. I'll see if I can figure it out for you.
Okay, thank you.
Yep. Okay, Linda is saying, please clarify if we're not correct. All listing purchase contracts with compensation clearly stated signed prior to August 17th and listing was on MLS, but will close after this date are grandfathered in. Linda, I am not sure about the grandfathering. I've been asked this a lot and I've tried to research it. I would say that they are not grandfathered and you should get compensation agreements signed just to be safe. Mary is asking, NAR offering a go over all the new changes. I missed the last time. Mary, I have one on my YouTube channel if you want to see it about NAR forms. I did it on the 12th, so 3 days ago. Daniela, let's see, what did Daniela ask? Let's see here. Colleen, about open house. So open houses are, Colleen, a very good question. Open houses are more, if you have to know whether you are working with the buyer before you tour the home. And then if you are working with the buyer, you would need a showing agreement or something signed by the buyer. If you're holding a house open and a bunch of buyers just walk in, you are not quote unquote working with the buyer. So you don't need anything signed. They can look at the home. If, however, they ask you to write an offer, now you're working with the buyer and you need something signed, a buyer broker of something like that signed.
Sam, I have a
Okay,
question.
everybody. One last question. Back to you.
Okay, so we were taught, I just want to make sure I'm understanding it correctly from our broker. If it was a co-broke and on the listing agreement, they agreed to pay 3% to the buyer's agent for the commission, like it's always been.
Let's say
It's
X,
not
let's say X.
necessary.
The buyer agreed to pay X. Okay.
Well, right, the buyer agreed for 3% and the co-broke, per the listing agreement, they allowed to share, it was
A portion
6% and
of
they
it?
agreed 3%, whatever. But then it wouldn't have to be notated in the additional notes because it's just the way it exists now prior to August 17th. However, if the listing agent was unwilling to share their listing commission, and it was the seller who was specifically offering compensation, then it would have to go in additional notes.
That's correct. In other terms and
So-
conditions, additional terms, you mean? Yeah, you'd put that in additional terms. That's right.
Only if it's a seller. If the listing contract and the listing broker is agreeing the co-broke, then it doesn't have to go into additional terms, kind of like the way
Right.
it is.
You run
correct?
into the problem of what happens when the listing agent won't share the compensation immediately. They want an offer first, so you have
Well,
to make an
right,
offer.
yeah. Well, we have a form that we would have them sign prior to giving the offer so that we make sure that it is in writing. That would be okay.
Yeah.
Okay, thank you.
All right, everybody. Send me an email with your additional questions. My information is on the screen. It has been wonderful to talk to you all. I really appreciate it. Just stay together and stay tough. We'll get through it all together. I will talk to you all soon.